Welcome to Shooting Straight with Brad and David. I'm Brad Carlyon, your Navajo County Attorney.
I'm David Clouse, your Navajo County Sheriff.
And our guest this month is Jason Moore, a civil deputy with the Navajo County Attorney's Office. And Jason, we invited you here to talk about civil asset forfeiture, which is once again a big topic in our state legislature.
It is. And I've really been looking forward to being able to talk with the two of you about the bill that's in front of our legislature right now.
But first, what exactly is civil asset forfeiture?
Well, civil asset forfeiture is a civil process that is designed to go after the assets, the proceeds of criminal enterprises, basically, to deprive them of their ill-gotten gains and to deprive them of the instrumentalities that they use to commit their crimes. And it's long established here in the United States. You can trace it back to the 1700s here in the United States, and before that back to Great Britain. It is a long-standing procedure.
Do we actually do very many of the civil asset forfeitures in Navajo County?
Oh, I would say that, and this is just in an average month, we might have 5 to 6 cases come in a month, but that's probably the most we do.
And can you give us some examples that people might know about but didn't realize that there was civil asset forfeiture involved in those cases?
Well, sure. I can give you a couple of examples. First off, I worked with Mr. Clouse, Sheriff Clouse, before he became Navajo County Sheriff on a case called the Silver Creek Irrigation District case, which I know a lot of local people may know about. That was a case where the bookkeeper of the Silver Creek Irrigation District embezzled over $800,000 from that special taxing district. And through civil asset forfeiture, working with David, we were able to get a recovery, not all $800,000, but we were able to get a nice sizable sum, about a little over $230,000 through civil asset forfeiture, which we were able to return to the Silver Creek Irrigation District to directly benefit the taxpayers and property owners in that district. That's one example. A second example, we did a civil asset forfeiture case on a drug house in the Winslow area, where an individual was selling heroin, also selling methamphetamine. Out of a house there, and we were able to do a civil asset forfeiture on that house. And it was really important that we do that because if we take that house away from the individual who was using it to facilitate his drug crimes, that prevents him from just letting somebody else that's part of his network, one of his criminal friends, start running drugs out of the same house. But we were able to get that house forfeited on the market, cleaned up, and we've removed that from the Winslow community. So it's really, those are just a couple of examples of how we've used civil asset forfeiture.
It sounds like with the Silver Creek Irrigation District, the money that you were able to obtain through the civil asset forfeiture went back directly to the victims. But in the case of the drug cases, like that drug house in Winslow, what happens to the proceeds of the money if you get a civil asset forfeiture?
Well, sure. The house in Winslow was sold after we obtained title through the civil asset forfeiture process. And when the money was sold, that money goes into what we call the ARF fund, or the Anti-Racketeering Revolving Fund. And that's set up by law. The money that goes into the ARF fund is only allowed to be utilized for very specific purposes that are set forth in the law.
Like what?
For example, a lot of it. Well, for example, number one, helping crime victims. That was the Silver Creek Irrigation District case, but we're able to use it for things like law enforcement equipment to repurpose the criminals' money to go back after the criminals, which makes a lot of sense. It's good common sense. But we also use that money for things like funding drug education programs, drug prevention programs, gang prevention programs. We can use them to benefit other crime victims. I mean, there's a lot of good uses that money goes to.
David, how has the Sheriff's Department used some of these ARF monies?
That's a great point and great question. Is a lot of people wonder what goes. So with the sheriff's office, with those ARP funds, we of course use it for more enforcement, right? We have a drug task force. It's called MCAT, Major Crimes Apprehension Team, and it's used to buy, say, equipment. If we need new ballistic vests, or if we need helmets, for these high-risk type search warrants, or if we need vehicles for our task force members, then it can be used for that. And most importantly is we use it to invest back in the communities where that drugs was being sold and where those assets were seized from. So we're taking bad money or drug money that was once used to poison a community, and now we're reinvesting back in the schools. We're reinvesting drug prevention programs, drug treatment programs. Brad, you and I joined quite often with different causes, domestic violence shelters, the Bread of Life mission in Holbrook, one of the few homeless shelters that we have in the county. They always need support, and so when we talk about rehabilitating people and trying to get them out of the system, what better use of money that used to go towards targeting these victims, and now we're using it to target treatment for them. And the Drug Nexus Coalition programs always want to target the youth, right? Because they say that's when they're most vulnerable. And so we always try to plug that back into Heber, Overgard, Joseph City, Winslow, Snowflake, all these communities that we have jurisdiction in, and to those school programs, give these kids an alternative outside of doing drugs, giving them an alternative of programs that teach them not to do drugs.
One of the things I hear about in the legislature and these people who are against civil asset forfeiture is policing for profit. From what you described, it doesn't sound like you're making a profit off of this money, but reinvesting it.
Yeah, exactly. It's used to, what we do with the Navajo County Sheriff's Office is go right back to drug enforcement and drug education, drug prevention. And it's kind of split up equally between those types of programs.
And Jason, are there protections in place to make sure that the different agencies that participate in the task force use the money properly? And can people find out how they use that money?
Absolutely, Brad. Back in 2017, the legislature adopted a law, HB 2477, which requires us to keep very specific data about all of our civil asset forfeiture cases and also about how that money is used. Those reports, we report those on a quarterly basis to the Arizona Criminal Justice Commission, and all of that information is available on their website. So the reporting requirements are strict. Any member of the public can go on that website, see exactly how those monies are being used.
And the county attorney's office has to sign off on any expenditure by any agency outside the county attorney's
I can testify
office.
to that because every single bit of forfeiture money that is spent comes across my personal desk for approval, and that's all the way down to, if they buy a box of paper clips for it costs $3. Yeah, I have because the law requires that every single time you use ARF monies, there has to be an application for it and it has to be approved by somebody. And so, yeah, I personally look at every single one of those applications.
So when we make requests to buy drug pamphlets or drug prevention pamphlets, right? For the schools, or if we buy equipment for our task force, we have to, one, make sure it meets the criteria, then you double check that for us.
And that's what I'm there to do, double check that. And yeah, absolutely.
And you don't have trouble saying no?
I don't have a problem saying no, and I have said no to some things before that I didn't think necessarily clearly met the criteria. I don't have any problem, saying no to David Clouse or no even to Brad Carlyon. So, yeah.
Besides this policing for profit argument that doesn't hold any water, at least in Navajo County, there's also seems to be concerns I hear about as to the process that occurs before to allow us to forfeit property. What is that process, and what protections are in place for somebody who may be an innocent owner or maybe not an innocent owner?
Oh, sure. Every single civil asset forfeiture case, the way the law is currently structured, has to go in front of a judge for approval. I think the people who are against civil asset forfeiture, something that they don't understand is that every single forfeiture that happens is approved by a judge, and at a minimum there has to be a showing of probable cause if the person didn't appear. But we also have innocent owner exceptions that are built into our current law, so that if there's folks out there who we have taken property from and they don't believe that there was a legal justification for it, they have the opportunity to appear in court by filing an answer or a claim, and at that point we litigate the legitimacy of that and determine whether or not there's basis for it. If there is, I'd happily give them their property back, and I have before.
So what are some examples of that? I know when these things are debated, you hear about there's no due process, right? And then you also hear about the innocent victims that are the government's taking their property.
Let's talk about a specific case. There's the Institute for Justice that always brings up this one case. They only give a slight version of the facts. But why don't you talk about that one, Jason, because it carries a lot of these different elements in it.
Sure. The case you're referring to is a case that's currently on appeal before the Ninth Circuit Court of Appeals right now. Basically that involved a case where there was a drug trafficker by the name of Shea Platt, and he had gone to Florida.
From where?
From the state of Washington.
So all the way across the country. That's
right. And he'd left a vehicle in the state of Florida for, it looked like, about 5 months based on the evidence that we had. He was stopped in Arizona for what was a routine traffic violation, but during the course of it, there was some suspicious things that the investigating officer from the Department of Public Safety noticed. There was a drug dog run around that vehicle, and it alerted, and when the vehicle was searched, there was over $32,000 found inside of it.
Cash.
Cash, yes. And of course it's, possession of cash isn't by itself a crime, but it's highly unusual. There were a lot of other factors involved that led the officer to conduct a seizure of both the vehicle and the cash that was found inside the vehicle. Basically, what happened after that is there's this very specific process that people who want to make a claim for property can. They did in this case. William and Maria Platt, Shea's parents, actually owned that vehicle, and they made a claim to the county attorney's office. At first, when the claim came in, I debated about how to handle it a little bit. Ultimately, I decided to return the vehicle to them.
But you would have had an argument to keep it, since the kid seemed to have it for an extended period of time. It wasn't, I just, Mom, Dad, can I borrow the car and run down to the store?
Well, and this is the issue with drug trafficking organizations and generally is that one of their tactics that they'll use is use a car in somebody else's name. They'll use a rental car so that isn't seized. In this particular case, frankly, there was conflicting evidence. On the one hand, the car was titled in the parent's name, but on the flip side of that, Shea Platt had been in possession of this vehicle for 5 months, where he claimed that it had been parked at the Miami-Dade airport, which is, it might be normal for a parent to borrow a kid a car, but under those circumstances, that's a little bit weird. And then also when we went through and analyzed the jail conversations, that when Shea Platt was in the custody of the Navajo County Sheriff, we listened to some of those conversations, because all of those inmate conversations are routinely taped. And one of the things that came across in that was that there was apparently some kind of an agreement where Shea was purchasing that vehicle from them. There was a reference, Shea said to his parents, well, I'll still buy the car from you. So clearly there was some kind of an agreement that was going on there. But
So why did you give the car back to the parents then?
Well, largely for a couple of reasons. I thought that it could be a close case, and in a close case like that, I'd prefer to give it back to the owner, and that's what we did in that case.
So what about the money in the car?
The money in the car, we proceeded forward with that. We did a lot of really good investigative work on that. We got the cell phone downloads and from both Shea Platt and his passenger and assistant in those particular crimes. Those cell phones proved beyond any doubt exactly what they were up to, that they were both involved in the sale of illicit drugs, and that the money in the car was related to that. And so we proceeded forward with that. We also went up to Washington State. We did interviews with some of Mr. Platt's friends, associates, and one of the things that we learned during that process was that William and Maria Platt, who were Shea's parents, had specifically gone out and approached a friend of Shea's after he was arrested and asked that person to tell a false story that he was in fact employed by that individual, and that they wanted to use that as a cover story for why Shea had the money. So, and I don't fault the parents a lot there. I mean, I think every parent wants to see the best in their child, but a lot of times parents have blind spots, and yeah.
So it sounds like in the civil forfeiture process, the first protection for people is the county attorney's office.
That's correct.
Saying, this is yes or no. Mm-hmm. And then there's even the judicial process with the judge making the final decision if it's challenged.
That's correct, yes.
So there's a lot of protections. And you talked about due process. It sounds like there's due process.
There is, yes.
So what were the issues the Platts have been appealing that they keep going to the Ninth Circuit on?
Well, you have to understand that there is a procedure written into the forfeiture statutes called and it's a misnomer, but it's called uncontested forfeiture. And basically what the process what the idea is under uncontested forfeiture is you send notice to the property owner or interest holder and that you're going to seize the property, and then they get back with you, establish standing that they do in fact own the property, and why they think that they're entitled to receive it back. The law requires those things to come to us under basically it requires them to make a sworn statement, under oath that, yeah, this is my property and this is the reason why I should get it back. The Platts didn't do that. And so the position of the case at the time was that they were going to, I went ahead and applied for an application for order of forfeiture with the judge, and the Platts objected to that, and it was in a posture where it was going to end up being heard before the trial court judge and so that was the disposition. That was the position the case was in when the Institute for Justice became involved.
And they've lost every step of the way.
Yes, they sued us in federal court. They lost every single claim that they had made in the federal district court. Now they're in the Ninth Circuit Court of Appeals, arguing that they should be given an opportunity to have the case remanded back to state court so they can make state law claims.
But they made those state law claims in federal court.
They did, okay. But yeah, exactly.
So, this is a case of one of many. I think some other claims out there is that the sheriff's office or any other investigative agency may stop a vehicle in a local community and somebody has, since the passage of 207, prior to that, a small amount of marijuana.
They had a joint.
They had a joint,
yeah.
Or they have a pill or two, or they have maybe a little small amount of methamphetamine. Are those the types of cases that we're presenting to you for asset forfeiture? Or are you seeing, what are some more common types that you actually see from us?
No, having personal possession of really any drug, and not just marijuana, but if it's a simple personal possession case, you're not going to see a civil asset forfeiture case happening on that. However, there can be cases where either the sheriff's office or one of the local police jurisdictions have been investigating somebody for a period of time because they know they're selling in our community.
Yeah.
And they might get them with an amount that is below threshold that is presumptive in Arizona for sales, and we might end up doing a forfeiture even though they were below the threshold. But in those cases, there's not just the actual drugs involved. We've got we might have controlled buys on them. We've got cell phone evidence that what they're involved in. We right.
Have a history built on them.
Yes.
So we're going after the dealers.
We're going after the dealers.
And
yes.
the transporters.
Absolutely.
The drug cartels.
Yes.
So if you see, if you follow us on our Facebook, we often put a lot of our interdiction stops where we have, whether it's on 377, 260, I-40, we're seeing vehicles with large quantities of drugs going eastbound and sometimes large quantities of cash going westbound.
Yes.
And then part of our investigation is we look to see how many border crossings this particular vehicle had or this particular person has, and sometimes we'll see 2 or 3 crossings in a week, and those are the ones that we'll sometimes bring to your attention to say, here's a case where they're westbound with large, $30, $40, $50, $100,000 in cash, and they've crossed the border 3 times this week. What is that an indicator of?
Well, basically that's you always look at every single case is unique on its own facts, and it's not just one fact that's going to lead you to probable cause. I mean, there might be a legitimate reason why someone's crossing the border multiple times, but you look at that along with all the other facts, and law enforcement knows a lot about the patterns of criminal organizations.
Yes.
A lot of times we'll get money loads that are going one way and the drugs are going the other. And in those cases where we get the money loads, we're almost never going to get a criminal conviction in those cases.
Why not?
Because, well, it's a good question, Brad. And the biggest reason is because although we can, we may get really good evidence. We may get evidence that from their cell phones that they're directly involved in drug activity. There may be a Santa Muerte icon on the front dash, which is generally considered the patron saint of drug traffickers.
Yeah.
You might have a positive drug dog alert, both on the car and the cash, indicating that the cash has recently been in close possession with illegal drugs. You might have an individual who is changing their story constantly about where that cash is coming from. It's
just
not
a mule who doesn't even know how much or where it's hidden in the car.
Yeah, but you always look at the multitude of facts, and it's not just one thing.
So there's a bill in the Arizona State Legislature this year to cut the legs out from civil asset forfeiture and our ability to hurt the cartels and the drug dealers where it counts their economic monies.
Yes.
Well, what is it about the bill that really cuts the legs out from civil asset forfeiture?
Well, there's a lot of things wrong with this bill. I could basically put them into 4 areas. Number one, it will require a criminal conviction prior to ever initiating a civil asset forfeiture proceeding.
So just like the cash we talked about, we're not going to be able to get it because we can't always prove that person transporting knew what he was transporting.
And the sad truth of that is because we can't prove that he was involved in drug trafficking beyond a reasonable doubt. I'm going to be forced to tell Sheriff's Clouse deputies, individuals with DPS, that, hey, we need to take this money that we know is involved in drug activity. I need you to take it and give it back to the drug traffickers. That's not going to be a great situation. Sheriff Clouse isn't going to want to hear that, and I don't think most of the public wants to hear that either. But that's the sad truth about what's going to end up happening because of that. So that was one area. The second area where I think we have major problems with this bill is that, for example, in the Snowflake irrigation case, the proposed legislation, SB 2810, which is being considered right now, it's going to eliminate a statute, 132314G. And I know most of people listening to this show don't know what that statute does, but that's the statute that allows you to do interim forfeiture proceedings for all of the racketeering crimes. And those things include things like theft, embezzlement, everything like that. And without that statute, we're not going to be able to go after. You literally, after this bill becomes law, you can go out, you can rob a bank, buy a bunch of other stuff with it, whether it's houses, your Ferrari for yourself, whatever it is. And because we don't have that hook in 132314G anymore to file a civil asset forfeiture action, we're not going to be able to go after those assets in embezzlement, forgery cases, stuff like that.
So they'll be able to keep their ill-gotten gains.
They'll be able to keep their ill-gotten gains.
They'll be able to keep the money from the bank.
It's good for it's
as long as it's in a different form.
Yes,
if it's still
that's
money
right.
from the bank, we could take it back. But as soon as you spend it on something, we can't touch it.
Or if you gift it to somebody else. Then
the other two, we got just a couple minutes left. The other two areas that you're concerned about?
Yeah, post-deprivation hearings. Say that you did see something. Basically, what the new law would give them right to what's called a post-deprivation hearing. And under that, they would be always be entitled to receive their money back if it isn't going to be used in the criminal case against them. And so, for example, in my example about the bank robber, if he went out and turned that into a different form by buying a house or buying a car, well, those things aren't really relevant to the criminal case. You're never going to introduce a car into evidence before the court. First off, you can't get it into the courthouse, all right? So that's going to be a problem. You can't do it with the house either. And so what the statute as drafted currently says is that if that isn't going to be used for evidence, it automatically, the trial court judge has no choice but to return it to the criminal.
So they could dispose of it that way and hide the assets afterwards.
That's right. And the other part of the post-deprivation hearing that is terrible is that if the criminal defendant comes in and tells the judge that I can't afford to hire an attorney, we have to give that property back to them so that they can fund not only the defense of their criminal case and hire an attorney of their choice, but also so that's bad enough.
Another way to launder it. And unfortunately, Jason, we're out of time.
Yeah.
But thank you very much for talking to us about civil asset forfeiture.
Thank you.
And thank you for joining us this month on Shooting Straight. And please stay tuned for this month's Most Wanted.
Thomasina Marissa Long, 36, has a valid and confirmed felony warrant for failure to appear on original charges of dangerous drug possession and drug paraphernalia possession. Thomasina's last known address was Winslow, Arizona. If you have any information on the whereabouts of Thomasina, please call Navajo County Communications Center at 928-524-4050. Or to remain anonymous, please call WeTip at 1-800-78-CRIME.